Welcome to CAM Radio, an Ahead of the Curve initiative by Cyril Amarchand Mangaldas, bringing you every Friday the latest in legal and policy. Stay tuned. Enjoy listening.
Introduce two of India's biggest legal stalwarts and luminaries in the form of Mr. Amit Desai, Senior Counsel, Senior Advocate, Bombay High Court, and a very well known in the criminal procedure and the criminal practice. And of course, my senior, Mr. Cyril Shroff, Managing Partner of India's leading law firm, Cyril Amarchand Mangaldas. This combination, or this lethal combination, if I may put it, is going to discuss today the three new criminal laws and legislations which we understand is going to take effect on 1st July 2024. Briefly, the present session intends to cover, in the backdrop of the three new laws passed by the Parliament in December 2023, the Bharatiya Nyaya Sanhita 2023, for short BNS, the Bharatiya Nagrik Suraksha Sanhita 2023, for in bracket BNSS, and the Bharatiya Saksha Adhiniyam 2023 BSA, repeal and replace the Indian Penal Code of 1860, the Criminal Procedure Code of 1973, and the Indian Evidence Act of 1872. And now leave it to Mr. Shroff and Mr. Desai to share their views on a very engaging and promising conversation. Thank you.
Thank you, Ankoosh, for that introduction. And let me also add my warm welcome to Amit Desai for joining this discussion. We'll spend about the next 30 to 40 minutes focusing on the general development because of these three new laws coming in, and in terms of what we should expect in terms of as these laws start getting implemented. But before we get to what the impact will be, I think it is appropriate that we go a little behind the drivers that led us to this and discuss what were the key motivations for introducing these new laws. What is the background? Why did these three laws come? The Indian Penal Code, CRPC, and the Evidence Act were apparently working quite okay for a while, and the Indian legal system had got used to it. What was the reason why we needed these three new laws? What's the background and what led up to it? So Amit, can you give us a little bit of background history?
Yeah, sure. So Cyril, firstly, thanks for having me on your program. I mean, it's extremely great. It's a great initiative, and that is being carried on by all of you. And I think these kind of interactions are necessary and critical for not only the legal fraternity, but for all members of the community to understand it through how new laws and regulations are coming in. Because I remember when we started practice nearly 40 years ago, we didn't have these opportunities, and a lot of the lay people never really understood the lay of the land in the context of the legal requirements. And I think today, most citizens are very curious and keen to understand the legal obligations that govern them. So in that context, I think that's a great initiative that you have taken. And I think the three legislations that we are now talking about are so fundamental to any society. And therefore, obviously, and this is very unlike, regulatory laws, which may be industry specific, etc. But these three legislations actually impact the entire society and the citizenry, so to speak. And therefore, obviously, these laws have some very serious implications, and people need to understand, what the laws are about. But in that context, let me therefore address the question that you just raised: is what really might have been the key motivation for introducing these laws. So I think I have a mixed opinion about it. I think some of the laws really did not need any major significant alterations. And therefore, they could have been amended, but they didn't need to be completely rewritten. So what really is the motivating factor for bringing about the new bills in the names of Bharatiya Nyaya Sanhita, Bharatiya Nagrik Suraksha, and the Saksha Adhiniyam is a matter for which I think there is still the jury is out as to what is really caused this change. But having said that, there has been for quite some time discussion and debate within the government and the law commissions to try and see whether we can rework some of these laws. And this conversation has been going on within the Law Commission and the parliamentary standing committees for nearly over 10 to 15 years. And it was more in the context in which those conversations are happening was a comprehensive review of the criminal justice system of the country. And, in these three legislations, there's a significant overlap because the penal code or the Nyaya Sahita really is the set of provisions which govern society, so to speak, because they deal with natural offenses largely. They are body crimes and property crimes which govern societal behavior. And then the question was, how do you ensure that those crimes, how are they dealt with in a court? So there is a procedure code, which is a Nagrik Suraksha. And then obviously the Evidence Act is what is the basis on which you can convict or acquit in relation to this, which is the Saksha Adhinyan. So these three are, in that sense, three cohesive legislations, and therefore, when there was a conversation about a comprehensive review, it was actually to try and ensure that there is a continuum within the three legislations, so to speak. But that's how I think it started. The second thing that obviously was key to all these changes was largely in the context of Nagrik Suraksha, which is the procedure code, where the challenges of the last 40, 50 years of how to ensure that there's speedy justice and the rights of victims, the rights of the state and the rights of the accused are balanced in that particular legislation. And time has shown that, we've never been able to really deal with the principles of speedy justice because justice in the criminal here is significantly delayed. Cases run on for 10 years and 15 years and 20 years. And that was never the intent of the criminal justice system. So that is one element which I think is a key motivator to bring about the change. The second key motivator is very clearly the need for introduction of technology in the space. Because ultimately now the world is heading in the direction with the 21st century, everything is about technology. So how do you bring in a lot more technology, both in the context of investigations and in the context of running the litigation in a criminal court? So I think that is a significant motivator. I think that should have been the only motivator. And Nagrik Suraksha would have been the main legislation where changes should have been brought about to achieve these objectives. I'm not so sure about the Nyaya Sahita. And of course, I think the Evidence Act needed changes. And when we talk a little bit more about it, I think there have been some missed opportunities in that context. So I think this is where the way I see this position about why the change. I'm not sort of very clear about how, from a legal standpoint, Nyaya Sahita and the Saksha Abhinyan needed such a change in that sense.
So I agree with you, Amit. I think first in terms of just getting speedy justice, because we have cases that go on forever under trials who are in jail, but they've not yet faced the trial itself for running into decades, and therefore giving us the bad reputation of highly delayed justice. The second part, as you rightly said, was about modern technology. But if I can just zoom out one more level, and this is the kind of intangible thing which government has talked about, is to Indianize a lot of these legislations, except the CRPC, are pre-independence from the British Raj. And while they were impeccably drafted at that point of time, there is a general feeling that after 75 years of independence, that we need to shed our colonial legacy and Indianize and evolve and apply laws that are meant for today's India. How far do you think, apart from the title, which has changed words like Penal Code and CRPC and Evidence Act and given it an Indian name, what elements in the actual substantive legislation really address this issue of Indianization? What is Indian about it?
Let me share my own personal perspective, and I've said this before. I don't believe that these legislations were in some way what are being described as colonial, because ultimately, what is the meaning of colonial? Colonial was a form of ruling where we were being ruled by another nation, and therefore, if the laws that were being introduced were such that really benefited the ruler rather than the ruled, then I would have called that law colonial. To some extent, there was a debate and a conversation that the provision on sedition in the Indian Penal Code was more colonial than what was required. But outside of that, if you actually look at the Nyaya Sahita, there is nothing colonial about that legislation from day one. I'll just give you a little history. The last
Yeah, these are just normal civil society.
That's why I said, I'll just give you a little history. In the 1800s, when these three legislations were actually, in a sense, codified in India and by the Britishers, because they were at that time ruling India, the reason for the codification of these three legislations at that time was that because India was an amalgam of British ruled states and princely states, and in those days, the different states had different laws, and in order to bring some kind of a cohesive unification across the continent, there was a need felt for codifying the legislation. This is an effort that was being taken in other parts of the world also. So whether it was the penal code, which had different nuances and ingredients in different parts of the country. There was the Evidence Act. Some of it was not codified, and all principles of Evidence Act moved from judge to judge. The Procedure Code moved from princely state to princely state and judge to judge. It was necessary to kind of have a cohesive, unified form. Therefore, there was a codification process that happened in the 19th century, virtually through the year. Having done that, what did they actually codify? So when you look at the Nyaya Sahita, essentially, all the offenses are those which are offenses in the against nature. So whether you have body crime, or whether you have property crime, so whether you have murder or injury to body or gender crimes, all of this is a crime across the world. They deal with morality, and therefore none of this was in that sense colonial. Whether it is in England today, in Europe today, in America today, in China, in any part of the world, you will find that murder is murder, rape is rape. Certain property crimes like we have of forgery and fabrication and cheating and breach of trust are all crimes across. So there was nothing colonial to start with, and it's not going to be decolonized because of the change in the title to the legislation. Even in India and in the princely states, these were still crimes, even before the codification process. So if you ask me, that except for the Nagrik Suraksha, which is a procedural law to ensure that there is some balancing of rights amongst parties, the substantive law was never colonial to start with. So far as the Evidence Act is concerned, when you look at the principles of evidence law, the jurisprudence of evidence is underlying is still the same across the world. You may tweak some provisions here and there in an attempt to try and speed up the process of a trial, but the fundamental principles of relevancy and admissibility are broadly the same across the world. So therefore, I don't think that there was anything colonial about it, and therefore nothing has been decolonized in that sense. The only thing that has
So
been
that's more a political message of Indianizing it.
Yeah, but
More perception.
And actually, when you actually look at the acts, there are barely any changes in terms of the language to both the Nyaya Sahita and to the Saksha Abhinayam. Barely any change in the act.
So as a practitioner who's practiced in this field for over 40 years, what really will change in terms of the approach to practice? Is it just the old wine in new bottle? Or what we're going to change on the ground in terms of how you practice?
I think the changes are more substantive in the procedure. That is really where the change is. And really, the procedure law is the most important law today for discussion, because the procedure law actually deals with the rights of parties. The offense is the offense. It's necessary to provide for these kind of offenses in order to regulate society. But it is how you then go about implementing these laws, which is through your Nagrik Suraksha, is where the change comes. So therefore,
so give an example, give a couple of examples, and if you can also relate it to things like personal liberty, how long, how the process works, because it's very often said that in the Indian justice system, the process is the punishment. So how does this get better?
So I think the interesting thing which has happened in this legislation is, I think, that recognizing the 21 rights, this is one area. What we find is that at various stages, they've now started introducing certain timelines for completion of the litigation. So there are various stages in litigation. They've tried to put in timelines. This is coming in for the first time as a matter of law, as a statute. Whilst in the past, we had construct of 21 by the Supreme Court, which would talk about speedy justice. It never came down to actually which part of the process should be speeded up and how. Therefore, this is the first time, and I'll give you some examples of where all the legislation has brought in timelines which will help to try and make sure that there's a speedier progress of the investigation and the trial. So let me give you some examples of how this is working. So they've introduced that when an FIR is registered, it has to be if it is an online registration because of technology changes, it must be signed within 3 days. Very often it used to be delayed and therefore investigation not proceed. So they say within 3 days you have to sign it, otherwise the FIR will not process. Then preliminary inquiries. So whilst the Supreme Court in a constitution bench judgment in Radhika Kumari introduced the concept of a preliminary inquiry, and that was a very salutary provision that was brought in. They've now made it part of the statute because earlier it had to be interpreted and read into the statute. They made it part of the statute. So I think that's a positive. The Supreme Court had provided.
Some of this is codification of practice into the CRPC.
Yeah. So what happens as a result of the codification is you'll have hopefully uniformity across the country to ensure there is a consistency, because otherwise across the country every jurisdiction and district will have
in a way it kind of rebalances the power equation between the state and the citizen.
That's correct. That's right. So that's where this is where the changes will start happening. So then even a citizen says a preliminary inquiry in 14 days, whether it's a victim or a suspect. He knows that in 14 days I should know whether I'm going to have an FIR or I'm going to be a suspect. You have some clarity about it. So the timeline they provided is 14 days. Now I personally feel 14 days is not adequate. Supreme Court had said 6 weeks, but they've cut it short to 14 days. But the first, that's why I said one is there's a concept of preliminary inquiry. Now they provided a 14-day period. Then
can you talk a little? You mentioned this. Can you talk a little bit about online FIR, because that improves the access to justice enormously.
That's correct. I'm coming to some of those issues. So when I'm talking about access to justice, Cyril, I will touch upon what you're saying. But it's not just about the FIR. There are various other stages where I'll touch upon access to justice. Then let's take the process of investigation. So there's something called a non-cognizable case. Now those earlier would be filed in a police station. They'd remain on a file for weeks, months, and years on end with nothing happening, with no supervision of the police force, no monitoring by courts. What they've now provided is every 14 days, some report should be given to the magistrate. Now, if a non-cognizable case is something which is serious, but the police have wrongly registered as a non-cognizable case and the citizen is being affected, now a court will come and intervene and monitor the police. So that's a positive sign and a protection of the citizen's rights when it brought in the question of monitoring once in 14 days. You then talk about investigation. Now, when you talk about investigation, you deal with it in different levels. So when is a question of an inquest report or a medical examination in the context of a rape, now those, there was no period provided for in law. So there was a misuse by police very often. If some accused knows the police officer, he slow it down, etc., and victims would suffer. They now started putting timeline that you shall make a report to the magistrate within a specified timeline. So you have protected the rights of victims and have a court supervise the police in that context. So I think that's a positive. Search records, there's not a scope for tampering. They said sorry.
So these are again falling in the category of efficiency and access. And
so you will find a series of all this.
There's nothing Indianized about this.
It's not typical. It's Indian. It may be Indian to the extent.
Could be anywhere.
Yeah, it should be. It is anywhere. But I suppose it's Indian to the extent that it's a recognition that there were problems within the Indian policing, and therefore this is now an attempt to try and protect having some judicial control over the police in relation to an investigation. So it recognizes and tries to protect citizens' rights by having this supervisory body, mainly a judicial officer, supervising the police. So this is
that is salutary.
But that is positive, and I think it will help improve the Indian policing of these matters. So that is I think that's a great positive as I see it. And if it works with the underlying intent, then I think it should hopefully curtail abuses in the system also by judicial officers supervising investigation. So I think that's a positive if you can see it. In like that, Cyril, there are a lot of issues, but let me give leapfrog to the courts. I gave you a few examples of how investigations can be kind of speeded up and there's some protection. But let me tell you what happens in courts. In so far as the trial itself is concerned, they've got some examples where if once a charge sheet is filed, documents have to be handed over to parties. So that takes sometimes weeks and months to even just hand over the documents. So they've said, no, you will hand over the documents within a time frame. So it speeds up that process. Then he talks about the framing of charge. So they provided a timeline for framing of the charge. So he said that it can't be dragged out endlessly. Where accused are probably delaying a matter, they say, sorry, it has to be gone. Because this is within the system and in the courts, they've also tried to bring in various timelines in an attempt to try and speed up the delivery of the justice. The last stage where they've done it, which I think is a bit of a problem, is that the judgment must be delivered no later than 45 days from the closure of the trial. I think that's a bit of a challenge because it's not easy. Judgment is about appreciation of evidence, and there are complex trials. It is not easy to appreciate the entire evidence in 45 days and render a judgment. I think it does a great injustice to the delivery of justice. And there were ways of actually dealing with it because there are some which are summary trials and summons trials where you can say, okay, I'll finish it in 30 days.
But I'm quite hopeful that the system will find its new balance.
System will find its way
because even whether it's the Arbitration Act or many other statutes
exactly.
where timelines have been issued, somehow the system works itself out.
They treat it as a guideline for endeavoring to comply and work it out so that it's mandatory. And so long as there's overall supervision that these guidelines are being ensured.
The judicial discretion will, I think, intervene.
That's right. But as a positive to this whole law is now introduction of these.
The intent is to do things quickly and in a systematic way.
That's the positive, as I see it, of an attempt to provide statutory basis for all this. So this is one aspect of the whole aspect of speedy justice. The second aspect is access to justice. This is the other topic that you just touched upon. In the context of access to justice, what they've now done is obviously brought in trials through audio video. So that's a very major change. So you are able to now, wherever you are, accused are in faraway part of the country, you don't have to all the time keep flying down, traveling down. You might even now, accused may appear on a video, witnesses may appear on DC, evidence may be recorded on DC. So that also should hopefully speed up the justice delivery system by using it. And that's where I say access to justice. So whether a person in a faraway place wants to file a complaint in say a city where the crime is committed, then what do you do about it? So you have the ability to use this technology.
You can trigger it from. You can trigger the wheels of justice from anywhere.
From anywhere. You have your own lawyers from wherever you are who are able to dive in. So you have access to your lawyers, you have access to the justice delivery system. So I think that's a great positive. The challenge is that I don't think we are geared up anywhere to have the technology yet. But it's going to take years for the entire country to have that kind of technology.
But we are living in times where technology is a very big theme. So I think it will get there. I think it requires some investment by the state.
And I personally believe that time has come where if you don't make these moves, nobody will actually change turn the needle. Technology was always available for the 21st century, but states didn't do anything about it effectively to provide for it to the courts. So now if it's part of a legislation, there's a push, and that will help. So I
can come to this discussion from a different angle, and very interested in your personal opinion on this. Is taking all these three legislations in the round, has the system become fairer? Do you think, or do you think it has become harsher?
So
and there may be one or two exceptions on the harsh. So we'll come to that for things like organized crime, and which may be more in the unintended consequences. So leave that aside. But taking things at a 30,000 foot view, are we headed to a new era of a fairer justice delivery system or a harsher justice delivery system?
I'll put that into a few different parts. In terms of the process of delivery of justice at the court level, with the examples I gave you and several others, I think you have the scope of a fairer justice delivery process, be it for the victim, the state, or the accused, either which way. The biggest challenge in delivery of justice is about how you implement these provisions, be it from the point of view of an investigation or by the judiciary itself. And There, the question is, how do you train the investigators? If you are in a position to train the investigators to be impartial and objective, then I think you have an excellent opportunity to bring a fairer justice delivery system. You ask me from my experience over the last few years, I think that the implementation, the execution or the investigations that are being conducted don't necessarily have the same level of fairness that one would expect from an investigator. So if the training is good, it will be helpful. Hopefully, some of these measures of supervision by courts over investigators may help the process to some extent to bring about some fairer processes and delivery of justice. And the second is obviously we need very high caliber judges at the level of the magistrate, the sessions court, high courts, etc. So if all
Judges
that,
and also prosecutors and the department
and
also needs to be more trained.
that's right.
But taking a glass half full approach, maybe there's a real opportunity for in a country with so much diversity and such a large population, that maybe we are headed towards a kind of more contemporary, more fair system. It will take its time to settle in, but directionally that's where I think we're headed. So
I'm trying to be optimistic about it. Yes.
yes. Now let's take the dark side, if I may, or some of the unintended consequences, and talk of some of the provisions in the Nyaya Sanhita and maybe other provisions as well, which surprised you. And just this morning we had that conversation about organized crime as well. Just using that as an example, there could be others as well. So, what provisions kind of surprised you, and which may, as we go forward, have unintended consequences?
Yeah. So let me first deal with, since we were on the Nagarik Suraksha, let me deal with a couple of provisions there, which I think surprised me. And I don't know whether they were intended consequences or unintended. Some may be intended, some unintended. But let me take the first thing, which is of personal liberty. In the context of personal liberty, there are two things that have been brought about. One is they've talked about the concept of police remand and extended it, because under the current law, a police remand was available only for the first 15 days when an investigation commenced and the arrest takes place. They have now brought in the provision that this 15-day period, which should have been a continuous period of police custody remand, can be broken up for a total period of 15 days within a period of 40 days or 60 days, depending on the punishment of a crime. What that essentially can result in is that ordinarily we used to see that after the police custody is over and the crucial stage of investigation is over, a person becomes eligible for bail. If you now say that I can run this for 15-day period over 40 days or 60 days, then his ability to try and get bail on the 16th day onwards is diminished significantly, because the state will keep coming and saying, oh, my 15 days are not over, and indirectly keep people in custody for 40 days or 60 days, the case may be. So I think that is a problem area in the context of personal liberty.
Capable of abuse.
Is capable of abuse. The second problem area, which is that when you talk about a concept of judicial custody, and judicial custody is that once the police investigations are crucial stage of investigation, custody interrogation over, an accused is sent into a jail. Now, when he is in a jail, they earlier used to contemplate, because the language was slightly wide, would contemplate medical custody and judicial custody. If you're in a jail hospital, if you're in a house arrest, that could have been treated as a judicial custody. If you had got parole to go for an obsequial ceremony or somebody's marriage, and there was a police officer along with you, it's called parole custody, which was contemplated. All this was in the interest of the human rights of prisoners. What seems to have happened is that by putting in a tighter and a stricter definition of judicial custody, they have excluded all of this. And therefore, human rights of prisoners are likely to be...
So do you think the court will read into this?
So I'm hoping, because this is the challenge we face that as of, but that's the challenge, that when we go in, we'll have to now have 21 read into all these provisions.
Yes.
Try and now interpret it. But the challenge that I face is, we had an opportunity to avoid more of this litigation because with these years
Yeah,
of
this will create new litigation.
yeah, it creates new litigation and prisoners will have to wait for outcomes. If it was in the section itself, then it
Yes.
didn't need any of this.
It was statutory then.
And it was statutory. It was happening all these years. So it's not as if we didn't know about it. It was necessary to just provide for it here. We've now created.
But personally, I am hopeful that our
But-
judiciary will be fundamentally our judiciary is
I
sensible.
personally believe that our judiciary is very conscious of the constitutional obligations. But my
Yeah.
only concern is this is an opportunity for Parliament to provide for it to reduce litigation on these matters in courts. Because that's one of the objectives, is that the system is clogged with cases. We don't need more cases when the Parliament can have a legislation which is actually crystal clear, and these opportunities were there. So this is one
So
part.
ye to abhi ho gaya, now it's done.
Now
So,
this is there, but I'm just saying, you asked me the darker side and the
Yeah,
unintended consequences. So I'm telling
Yeah.
you that this is the
this is a very important one.
it is an unintended consequence that has come about. The other part of this whole thing is punishment, and not only just punishment, but commutation. So this is again an indication, because what used to happen is that under the law, commutation by the state or by court was based upon the facts of a case. Today, what they've done is that in the context of the power of commutation, they have now limited that power, so that they've said that on a decreasing basis, you can now say if you are you're suffering a death penalty, you can commute only to life. If your punishment is life, you can commute to 10 years. Now you've provided this entire thing in a statute. My own concern is that the unintended consequence of that is that you've taken away a discretion of a court or an authority to look at the facts of the case and then commute to a much lower level. Take the example of what is the famous case, Nanavati's case, where there was a commutation. Now, in today's time, in Nanavati's case, commutation would still have meant a minimum of 10 years. Now, you have taken away that discretion. That is the unintended consequence of the provision of commutation. So this is one part of the dark side. This is the Nagrik Suraksha. When it comes to the Nyaya Sahita, I think the challenge that we are going to face is that they've introduced within this offenses of terrorism and organized crime in the Nyaya Sahita. Now, there was a special legislation which dealt with organized crime and terrorism, which was the correct approach to this, because these are special offenses. And they are not offenses which impact society, unlike all the other offenses of the Nyaya Sahita. But they've introduced these here. Now, it's all right if they've introduced, that may be a philosophical decision to say, I'll consolidate within one statute, fine. But in doing so, they've now brought into this economic offenses and offenses involving economic security. And economic security has not been defined, and economic offenses are given such a wide definition that the concern that I have is, and this is again where I hope the courts will have to step in, is that even commercial crime, which we see on a daily basis, and you as a law firm will have so many corporate clients and business clients having some commercial crime issue coming up, whether it's a cheating or a breach of trust in relation to a bank loan, etc., has the potential of coming within the framework of an offense like organized crime. They run the risk because of the expansive definition that has been provided. And obviously, as you will understand, that no corporate or businessman would like the label that even if it's a commercial dispute with a bank or with a lender or whatever it is, an NBFC would want the label of being
It's almost like a terrorist.
Organized crime which borders on terrorism. So it's an optical issue. So they've given a very wide definition. I'm hoping some courts will step in.
So the regular bread and butter IPC stuff has got escalated to organized crime.
Particularly in relation to bank frauds. Specifically, when they look at the definition, they've introduced bank frauds into the definition of economic offenses. So I could have understood that if it was impacting the financial system as a whole, then that's a much higher degree than you can say it's an economic offense.
So just let's go back in history and assuming that this law was there, would the security scam of 91-92, how would it have been dealt with today? Would it have been organized crime?
So you picked a very good example, Cyril. Yes, if you look at the definition today of economic offense and organized crime, then significant possibility that the security scam of 1992, the Harshad Mehta scam as it is known, would have been part of an organized crime offense. You have the Ketan Parekh 2000 stock market scam could have been brought within the definition of organized crime. It is a very worrying thing. I mean, in fact, in the last many years, our bank fraud cases that a lot of your clients and other people's clients are dealing with, because what is the criteria? The criteria is that if there is a group of people who have had two charge sheets filed against them, then they constitute what is known as a syndicate as a basis for organization.
Even if there is no connection and there is no organization behind it, merely the multiplicity of charge sheets is enough to. So actually, starting at the wrong side of the equation, because there is no organized crime syndicate necessarily behind it, and that is what creates it.
Right. So these are the. I think these are.
How would you apply that to say? Would this apply even to say technology offenses? It could be any offense. So if there are multiple, if there are two charge sheets on a kind of a new age technology offense or cyber security.
Yeah. So the only criteria is that the offenses for which there are two charge sheets must be punishable with more than 3 years. So therefore, but 3 years is a very low benchmark in many ways for a organized crime charge. It's a very low benchmark. I could have thought if it was 10 years or some life or something, you could have said it. But 3 years, I mean, most offenses, be it regulatory offenses or penal code offenses, routine offenses are punishable with 3 years or more. So
there are two problems with this. One is it's a very low benchmark. And secondly, there should have been kind of more substance given to what is organized crime as opposed to just linking it with more than two charge sheets.
That's correct. Now, let me give you another example again of an unintended consequence is take the definition of terrorism. Now, in terrorism, they've introduced economic security. Otherwise, the definition is more or less the same as the definition in the UAPA, which is currently the primary legislation dealing with terrorism in India. So they've picked up that definition more or less and put it into this act. Now, while doing so, they've introduced the definition of terrorist activity includes economic security. I can understand sovereignty, integrity, all that side. Economic security. There is no definition of what is the meaning of economic security. In the UAPA, economic security had a definition which dealt with counterfeiting of currency. So they limited the definition to counterfeiting if it was economic security. Now they've not done it. Now, if you talk about economic security, I don't know. I mean, can I use an example that if there is a short selling in the stock market, then that is economic security.
If a short selling in the market which crashes the market would be an economic offense, and that person then would be an economic terrorist.
Then you're an economic terrorist. Now,
not a bad thing.
Now, whilst short selling is of different types, and some impacts are very large and some impacts are low, what is the threshold for economic security? Short selling is a permissible activity, but what is the threshold which would make it a crime and then affecting economic security? So I give that as an example that here you're now saying this is terrorist activity. So you have to be careful because, and I say this because as India is, charging towards becoming a developed nation with more than 5 trillion economy in the next few years, you need to have continuously foreign investments and Indian entrepreneurship without fear of growth. Now, there will be, people will invest, some mistakes may happen, things will go wrong, all that happens. But to try and get all of them into this category, I thought was a bit of an unintended consequence. And I still hope it's an unintended consequence and the courts will self-correct some of these provisions so that it doesn't get misused.
But this is more a legislative thing. I don't know if the word economic offenses is there.
Economic offenses are defined. So there's a challenge. Economic security is not defined. So there's no interpretation.
Yeah.
So if you take
anyway, interesting times for you, Amit, in terms of your practice. Lots of new topics for you to develop the law on.
Yes, I will keep looking for these opportunities and
but this is big. This is a milestone and a watershed moment in Indian criminal law in terms of the new concepts that have been added. Now, if I can, the last question, putting on the lens of an advisor to India Inc. and corporate India, what should be the 2 or 3 things that I should be most mindful of? There are good companies and bad companies, and the bad companies are maybe they have to find different solutions. But for the good or relatively good companies who don't like to get into trouble, are very careful of their reputation. But with this new era of criminal jurisprudence that has opened up, what should be the couple of things we should be watchful of as we advise them? And because we as a law firm, we're kind of the first filter and the first layer of advice before we come to somebody like you.
So I think Cyril, the important thing is for all corporates to be now watchful of how this branch of the law is continuously evolving. I think it's important for law firms to be continuously guiding the corporates because very often they are working in areas which may be gray, not realizing that it's gray. And it's important for them to be extremely watchful of some of the structures that they're putting in place so that they come in advance, take a view and make sure that they're not, crossing a threshold here. So when we talked about some of these offenses, which are the more serious offenses, but some of the other offenses were already part of the penal code, so they've understood how they work. As law firms, they'll have understood how they work. But there are some of these new areas which have come out where there's scope for interpretation, and it's important that when you advise clients, be it domestic corporations or multinational corporations. Now, in fact, you've got corporations moving out and corporations coming in. But they have to be cautious and careful and watchful of this. The other area which they have to be watchful is, and something which I didn't mention because we're running out of time, is that we introduced a concept of trials and convictions in absentia. So some of these offenses that we talked about are capable of being conducted, the trials are capable of being conducted in absentia, and there are convictions in absentia. One of the problems that we face in our system is that a lot of these matters, very often clients don't know because warrants are pending in the system somewhere. Now, if they don't realize it, they can be convicted, and then that has very serious consequences for clients. So they have to be watchful of all these matters on a more regular basis and not miss a date, not miss a warrant, nothing, because otherwise they're serious. But this is one. I think the other thing is obviously to try and honestly see how the law firms like yours and others should probably try and make things a little easier for corporate India and try and see whether through a process of departmental and delegated legislation, try and see if some of these can be clarified so that there is less, because as you understand, the court system takes a lot of time to self-correct these errors. And a lot of people suffer all through that period of few years by the time the court self-corrects. So the next effort is, I think, to start talking to government and seeing if kind of broad SOPs are put in place as to where these can be used and where these cannot be used, so that on an ongoing basis, corporates don't have serious consequences coming in. Because otherwise what happens is that the corporate in the first stage will be fearful of only stepping in to a certain business activity because of the uncertainty of some of these laws. I think it's important to start having a conversation and introducing SOPs which will work down, because then they have to inform the police at every district level where they can use the provision and where they can't use the provision. I think that's the second thing I would say is a recommendation to firms like yours.
Maybe chambers of commerce and industry should.
And they should, yeah. So and lawyers will have to formulate it, and the chambers of commerce will have to then talk to government and have internal SOPs which are put in place, because it's not possible to re-legislate some of these things. So that could be the other area which I think you should think about as firms look into bringing in the balance. I mean, those who are bad, and the system will deal with it. But here we are talking about those who our intentions are honorable, but yet somewhere get caught up in some of these abuses, and we have to try and ensure that they don't unnecessarily face consequences because
exactly.
And the training, and the third area is again training of the police department to ensure how to act in relation to some of these matters. These are offenses which should be invoked in the rarest of rare cases, as I see it, when it comes to economic security and economic offenses, because otherwise.
So these are all very big ideas and big concepts which require a lot more thought and a lot more stakeholder engagement of different, whether it's the police or it's the judiciary or the or the state itself in terms of how it formulates law and policy as well. And I think it's clearly a to be continued dialogue. I think we also need to involve the corporate sector in a representative capacity like chambers of commerce, and I'm quite excited to be able to do that. And I think this is probably a subject that behoves that kind of attention from a firm like us and a leading practitioner like you. So I think we should take this forward as well, and I want to continue this conversation with you both offline as well as I think we need more. This was just a trailer,
That's correct.
so that the audience that listens to our podcast gets an idea of the magnitude of what has happened,
Right.
and then sort of collaborate in terms of how to take this forward. So unless you have any last thoughts, Amit, it's almost an hour. I'll bring close to today's podcast. It's been a fascinating discussion, and certainly I learned a lot. This is not my normal area of practice, but as a curious student of the law, when we studied law together, this always continues to fascinate me. Any thoughts, Amit? You have the last word.
I would, so having spent so many decades in this area of law, I am hoping that although I've seen aberrations over the last few years in the implementation of the justice delivery system, I do sometimes see that the courts, and particularly the Supreme Court, is very, very concerned about what you earlier mentioned on the show, that the criminal justice system process the punishment. I must tell you that I have really rephrased the original adage of justice delayed is justice denied to mean justice delayed is justice received. It's essentially because of the process and the punishment that we are doing it. And I can see that the Supreme Court is also concerned, and that's why you can read everyday Chief Justices. The last 4 Chief Justices have publicly talked about how the district courts need to follow the principles for personal liberty of bail, not jail, and they're trying to understand why it is not happening. I think that's an indicator of how an effort is being made within the system to actually streamline and improve the system. And if that happens, and then on the other side, the state also trains its people well, then obviously I can see a much better future for the criminal justice system, because ultimately, as we all know, that both the civil justice system and the criminal justice system are the pillars of democracy and the rule of law in any country. And
Absolutely.
it's important that there is fair balance in both the civil and the criminal justice system at all levels. So I'm just hoping that, in this, as we need to say, we use the term of Amrit Kaal that we keep hearing about, there will be some hope for the future if all goes well.
Somebody was asking me the other day, what is your main expectation from, the new government, whoever it be, Modi 3.0 or whoever it is. I said, my main wish is that we get a better legal system.
So I must tell you that, there has been a desire of this government, and I must say that because I got a few calls, but then it didn't go forward, is a desire to bring about decriminalization of business laws. And I don't know if you saw just a few days ago, where the government is already talking about, the agenda for the next government. And one of the items on the agenda is once again decriminalization of business laws to try and make it. So if that process actually works itself out, then in some areas, in some spaces, from a business perspective, you feel that there is hope. The question will be that does the penal code actually, open up some other areas with unintended consequences, because these are legislation which will be implemented by the local police officer who doesn't have the same skill set as a specialized body under regulatory legislation. But anyway, it tells your direction. And therefore, and of course, I think there's a talk about a significant change in I think judiciary as a part of the infrastructure push is going to be an important infrastructure push, I think, in the next few years. So we're going to hopefully everybody's waiting for the good. And of course, we are at this stage in life where we spent 40 years. I don't know how many more years we'll keep doing this, but we'll at least hopefully see some good coming out of all this.
So on that profound note, Amit, let me thank you again for your time on a Sunday morning. Really appreciate the thoughts, and frankly, you've opened up topics for many, many discussions. that are to follow. Thank you so much. And thank you, Ankush, for setting it up.
Thank you for having me.